So welcome back to everyone. It's basically 10:30. I hope you enjoy your coffee break. And now we will be entering into the subjects that you can find on the screen. So on the legal part and on the financial guideline. And I would like to pass the floor to my colleague Valérie, who will provide to us a presentation on the legal and financial guideline.
Thank you very much. Good morning, and thank you, Georgia, for sharing the floor. So I will provide you an overview with the main legal aspects, focusing on the changes between H2020 and Horizon Europe, focusing on certain call-specific conditions, and going through proposal submission, admissibility, eligibility, exclusion, award, ethics, and also the consortium composition in terms of third parties. I don't know who's controlling the slides because it's not Giorgio, I believe.
You should have the control, try. It's working, you are moving it.
Okay, yeah. So first of all, the new features in the Horizon Europe proposal submission form, so Part A. There are new fields in Part A. So there's the researchers table, which is needed to follow up on researchers' careers. This is basically a Horizon Europe indicator. You also need to fill in the role of the participating organization. And there's a self-declaration on what's called the Gender Equality Plan, the GEP, and we will go more into that later on. Some fields have been moved from Part B to Part A. This is the ethics self-assessment, and also there's a new security questionnaire. We will give an overview of that later on too. And so I don't have control of the slides, so I think maybe it's the comm team. If next slide, please. So first of all, in terms of exclusion, so this is an obligation under the financial regulations. So we perform a check in the early detection and exclusion system database. So we check 3 times before evaluation, before award, and before grant agreement signature. And the idea is that applicants who are subject to administrative sanctions or who are in certain exclusion situations cannot participate. So this is a bankruptcy, in breach of social security or tax obligations, grave professional misconduct, fraud, corruption, deficiencies in complying with obligations under another EU grant agreement or another contract with the EU granting authority, and the creation of a shell company. And applicants will also be refused if during the award they misrepresented information required for participating, or they failed to supply that information. And they will also be refused if they were previously involved in the preparation of the call, which would entail a distortion of competition and therefore a conflict of interest. Now, in terms of eligibility, this new gender equality plan, so it's a new eligibility criterion under Horizon Europe, but it's not for everyone. It's only for public bodies, higher education establishments, and research organizations. It should cover 5 aspects: publication, dedicated resources, data collection, and gender disaggregated data on personnel, and training. So, as I said, it doesn't apply to other categories of legal entities, such as private for-profit organizations, SMEs, non-governmental, or civil society organizations. The idea behind this GEP is that at proposal submission stage, you will be required, if you are in the above-mentioned categories, to fill in a self-declaration. It's, do you have it or not? That's it. If the proposal is selected, having a GEP will then be necessary before the signature of the grant agreement. So to be clear, an organization may not yet have a GEP at proposal submission stage, but it must have a GEP in place at the time of the grant agreement signature. Now, in terms of eligibility, there's eligibility for participation, and there's also eligibility for funding. So these are 2 distinct things. Eligibility for funding, who is eligible? A legal entity established either in a member state or an OCT. OCTs are overseas countries and territories that are linked to certain member states, namely Netherlands, France, and Denmark. But also, you can be a legal entity established in an associated country to Horizon Europe. We have a few slides on that later on. Or be a low or middle income from a low or middle income country that are defined in the Horizon Europe program guide. Or there also can be countries that are announced in the call. We don't have additional countries announced in our call. Or exceptionally, if participation is considered essential. So this is a case-by-case assessment by the granting authority. It is quite exceptional. It's if basically the entity is considered as having outstanding expertise, as having particular access to research infrastructure, to geographical environments, or to particular data. Now, associated countries. So countries associated to Horizon Europe. So for the purposes of the eligibility conditions, a legal entity which is based in a third country that is officially candidate for association to Horizon Europe is eligible. The idea behind this is that at the time of the signature of the grant agreement, you need to have the association agreement in place, in force, to be able to be considered as a beneficiary. So entities established in an associated countries are treated as beneficiaries at the time of the signature of the grant agreement if the association agreement is already in force. But the association agreement does not need to be in force at the time of proposal submission. I am sorry, but I have an issue with there's an issue with the slideshow. Yeah, it's very slow.
Please just ask when you want to change the slide.
Okay. So the association agreements with the following countries have now started to produce legal effects. So you have the list here, naming a few, Turkey, Ukraine, Israel, etc. Next slide, please. And then we have the specific situation of United Kingdom and Morocco, which is what we just explained earlier, is that the negotiation process has started and association is imminent, and therefore they can be considered at proposal submission stage. Now, you might ask very legitimately the question, okay, my entity comes from United Kingdom or Morocco, so the association agreement is not in place yet now, but I can still participate. I can submit as a benefit. I can submit within the consortium at proposal submission stage, and this association agreement has to be in place at the time of signature of the grant agreement. But what happens if it is not in place at the time of signature of the grant agreement? Then there are a number of options that we can consider. We can consider that the entity is exceptionally eligible to participate because its participation is considered as essential, as we explained previously, or it can be transferred to the status of associated partner. We will go into that later on, see what an associated partner is. And also there's potentially, if the association agreement enters into force later on and it is retroactive, the status of association partner could be shifted to status of beneficiary with retroactive eligibility of costs. That's hypothetical, but it's possible. Or there's also the possibility for the consortium to either replace or remove this legal entity, always taking into account that the eligibility conditions of consortium compositions are respected. So the eligibility conditions of consortium composition are to have minimum one independent legal entity from a member state and minimum two others from a different member state or associated country. In the slide, you see here that Switzerland and Liechtenstein do not intend to associate to Horizon Europe, so they are not covered. Next slide, please. So as we just said, these are, they would be non-associated third countries. So non-associated third countries, any legal entity regardless of its place of establishment, is eligible to participate. So that does not mean it's eligible for funding, of course. So it's eligible to participate, provided that the conditions in the Horizon Europe regulation are met. And the exception, of course, are entities that are subject to EU restrictive measures. So in this case, to be brief, it would be legal entities from Russia or Belarus. So they can participate, but these legal entities from non-associated countries can participate, but they would submit their proposals as associated partner. Next slide, please. Now, in terms of evaluation, the award criteria are the same as in Horizon 2020, excellence, impact, and quality and efficiency of implementation. But there are specific sub-criteria in the EU Rail Annual Work Plan, which are listed in Annex 8. You will find them there. So the additions are quality of the proposed joint activities to achieve deliverables for excellence, for impact, quality and credibility of the action to contribute to achieving the EU Rail Master Plan objectives, and the impact of the multi-annual work program, and for implementation, appropriateness of the project management structure and quality of the proposed coordination. Next slide, please. In terms of scores and weighting, this has not changed either. For full applications, each criterion is scored out of 5. The threshold for individual criteria is 3. The overall threshold is 10. And to determine the ranking for innovation actions, the score for impact is given a weight of 1.5. Next slide, please. Now, ethics review, the criteria are the same as in H2020, except that they have been adapted to focus mainly on complex, serious cases and to reduce the number of ethics requirements in funded projects. So the idea behind the ethics review is that ethics ethic compliance is considered essential to achieve research excellence. This means adherence to the highest standards of research integrity and compliance with the European Code of Conduct on Research Integrity. So next slide, please. So when you submit your proposal, there's an ethics self-assessment that needs to be completed based on your particular situation. There's a guide link here that will help you complete this ethics self-assessment. And then there are ethics experts that conduct an ethic review and to see whether funding is authorized or not, and to see whether certain specific ethics requirements need to be put in place. These requirements that then become an integral part of the grant agreement as ethics deliverables. Next slide, please. The security scrutiny, this is new in your proposal submission form part A. Under Horizon Europe, there's a new security scrutiny. So security issues are checked systematically in all Horizon Europe proposals, and the checks are based on the self-assessment. The checks based on the self-assessment may then trigger a more in-depth security scrutiny. The idea is basically to check whether proposals use or generate EUCI, EU classified information, or send sensitive information. Next slide, please. The time to grant, I think everybody knows this. It's based on the financial regulations. So the time lapse between call deadline to the time when the results are notified is 5 months maximum, and the lapse between notification of results to grant signature is 3 months. So that makes a total of 8 months maximum. Next slide, please. Now, what will your Horizon Europe grant agreement potentially look like? So it's an e-grant, which means that it's fully electronic. From signature of the grant until end, all actions and communications flow in the funding and tender portal. It has been made more modular and user-friendly in the sense that there's a corporate structure with a commission, the corporate model grant agreement. And then there are specific provisions that are adapted in a modular way in Annex 5. And these involve security, ethics, intellectual property rights, communication, dissemination. Next slide, please. Now, in terms of the constellation of actors involved, how can you participate in the grant agreement? So there are various possibilities. First of all, the beneficiary. So who is the beneficiary? The beneficiary basically signs the GA or the accession form. They have the obligation to comply with all the grant agreement obligations to properly implement the action, and they are responsible towards the granting authority for the work performed by the affiliated entities, the associated partners, the subcontractors. So they sign the GA, so they're in the front line with the granting authority in terms of fulfillment of their obligations. There's another option. It's the option of affiliated entity. So affiliated entities, they're governed under Article 8 of the Horizon Europe Grant Agreement. It's basically the same notion as a linked third party under H2020. It's just that the terminology has been streamlined with the terminology used in the financial regulation. And they enjoy similar rights and have to comply with similar obligations as the beneficiaries, so mutatis mutandis. They have the obligation to implement action tasks, and they have the right to charge costs and contributions directly. There's also, therefore, the notion that they have to fulfill the same conditions of participation and funding as the beneficiaries. So everything we described on being in a member state, an OCT, an associated country, etc., affiliate entities have to comply with these conditions for eligibility for funding too. They do not sign the grant agreement because they're not beneficiaries. And they need to have a link. So you will need to have the proof of this link. They need to have a link with the beneficiary. So this link can be either legal or capital. A legal link means a link that is broad, and it generally predates or outlasts the grant agreement. So it would not be an ad hoc collaboration agreement made specifically for the purposes of the grant agreement. It would be something else. It would be a legal relation. So for example, a legal structure, association, membership, or an agreement. It can also be a capital link, and a capital link means being under the direct or indirect control of the beneficiary, controlling the beneficiary, or being under the same control as the beneficiary. So this covers cases of parent-daughter companies, subsidiaries, or affiliates between themselves. Another option would be associated partner, as we've already described. An associated partner, so this is Article 9 of the Horizon Europe Grant Agreement. So they do not sign the grant agreement, of course, they're not beneficiaries, and they do not receive EU funding, either de facto, because, for example, they come from a country that's not eligible for funding, or by choice. So they do not receive EU funding. They participate at their own costs. So they are mentioned in Article 9 of the grant agreement. Their tasks are listed in Annex 1, but there are no costs in Annex 2. And then the subcontractor, you can use subcontractors if it's necessary to implement the action. Their action tasks are listed in Annex 1. The characteristic of subcontracting is that it's a price, so it's not a cost. So a price entails a notion of profit. Therefore, since there's a notion of profit, there are also certain conditions that have to be complied with. It has to be limited in scope. It has to be proportionate in terms of action tasks. It has to be based on either best value for money, best quality price ratio, or lowest price. There must not be a conflict of interest. And there also cannot be subcontracting between beneficiaries, nor between affiliates, nor of coordination tasks. And maybe also the last element to mention in terms of subcontracting is that they're not under the supervision of the beneficiary. So they're not hierarchically subordinate to the beneficiary. And then there's a last notion of third party providing contributions. They do not perform work, they give in-kind contributions, and the beneficiary may declare the cost of these contributions. Next slide, please. So affiliate entities, I've already covered this. So it's basically the former LTP, linked third party under Horizon 2020. And the notion has been aligned with the definition of the financial regulation. So it's an alignment of labeling, but it's the same notion. Next slide, please. An associated partner, as already described, they are mentioned in Article 9 and the implement action tasks in Annex 1. But they do not receive EU funding, so either de facto or by choice. And of course, as already mentioned, beneficiaries are always responsible for ensuring that their third parties comply with the GA obligations. So proper implementation, absence of conflict of interest, confidentiality, visibility of EU funding, and record keeping, to name a few. Voila, so I think that's the end of my presentation, and I'm ready to take some questions. I think in terms of timing, Giorgio has discussed earlier, it's better if we take the legal questions now before the financial presentation.
Yes, if there are additional questions, I have seen in the chat one question to which I have already replied to clarify that indeed the associated partners can always participate. The difference is that they don't receive EU funding, and then the essential part of justification that we will need to have is only for in case there is a request to receive EU funding. I don't think there are additional questions. At least there are not. Yes, there is one in the chat for you, Valérie, if it is expected that Switzerland may join as well.
I do not know the specific intentions of Switzerland, but so far it has been quite clear that it's not in the pipeline. Who knows what the future holds, but so far it's not considered. They're not a candidate for accession in any case, so they cannot be considered as beneficiary in the proposal submission form. The only option for entities from Switzerland would be to be registered as an associated partner in the consortium setup.
Yes, and maybe just to add, normally those countries, and I think for Switzerland it is the case, they usually complement the fact that a company is not so that Switzerland is not associated to the program with possible funding that can come from the Swiss government. But then this is outside our remit. There is another question from Olivier. How about the UK?
So I don't know, Olivier, if you consider that the answer, you've been provided with a clear answer in the presentation, but so UK, you are entitled to submit as part of a consortium now at proposal submission stage. And then the joint undertaking will closely monitor during a grant agreement preparation stage the evolution, considering that the signature of the association agreement to Horizon Europe with the UK is imminent. So it should be, in any case, it should be in place at the time of signature of the grant agreement. We will closely monitor this. If it's not in place at the time of signature of the grant agreement, there are some options that are possible, as already mentioned. Either the joint undertaking, based on a case-by-case assessment, considers that the participation of this legal entity is considered essential, exceptionally essential, so based on outstanding expertise or access to research infrastructure, access to specific geographical environments, or access to particular data. This is, of course, a quite exceptional solution. The other option would be to basically switch the legal entity back to a status of associated partner and not beneficiary or affiliated entity, or to replace or remove, always considering that we have to comply with the minimum conditions of consortium composition for eligibility. So this means minimum one independent legal entity from a member state, plus minimum two other different entities from another member state or another associate or other associated countries.
Yes. And there is an additional question from Armando. So in fact, the UK has to be treated as Norway, but with the risk of not reaching an agreement in the end.
So yeah, so as just explained, they can be part of a consortium now at proposal submission stage, And there's, of course, always the risk that an association agreement is not in place at the time of signature of the grant agreement. But I think now it's quite imminent. So we have high hopes that it will be signed soon. And as said, there is always options to modulate participation at the time of the gap if the association agreement is not in place. So to be associated partner or to be considered exceptionally eligible for funding, or to replace or to remove.
Okay. There is another question from Simone. Please, could you list the essential about how a consortium must be formed, how many members, how many states, and or a link where to see it?
Yeah, absolutely. So the basis, the legal basis for this are the general annexes of the Horizon Europe work program. And in the eligibility conditions of the general annexes, there's the notion of consortium composition, as I just said. So you would need to have minimum one independent legal entity from a member state, plus minimum 2 other independent legal entities from different member states or associated countries. This is for RIA and IA. And for CSA, it's 1 or more legal entity from a member state or an associated country. So 1 or more. So the bar is lower.
And by the way, also concretely speaking, when you click on our call for proposal, you are redirected to the funding and tender opportunities portal of the European Commission. And from there, when also you look into the call topic text, you can find all the links that brings you to all the topic conditions. And also there is a Q&A in the funding and tender opportunities where you can find a lot of answer already. But Benedetta is writing to us, do the restrictive measure sanctions in force affect all the entities involved, the subcontractor, associated partners, etc.?
Yes, they do. They involve all actors involved. Indeed, as you, of course, affiliate entities, because they have to fulfill the same conditions for participation as beneficiaries, but also subcontractors, also third parties providing in kind. So all actors.
Okay, good. It seems that there was a satisfaction in terms of understanding of the different rules for participation. I would then suggest to move to the next presentation, and I give the floor to Vincent. I don't know if you want to try to take control. Yes, so you should have it now.